Now, this I thought was something else worth seeing. Joe, remember, focused entirely on the words that came out of the jury questions, out of the special issues. So the special issue in this case is going to be, among other things, especially on the issue of punitive damages, did McKinley and Company do what they did intentionally? Now, we know that intentionality is irrelevant. It's assumed if you've tortiously interfered, you intended to do it. So why did Joe do this? Let's go through it, and what you'll see is Joe moves very closely to the definition of punitive damages: intentional, willful, and wanton behavior in total disregard of Pennzoil's rights. Question: you tendered for Getty Oil intentionally and knowingly, knowing of the existence of the memorandum of agreement and the press releases. What can he say? It was all over the papers. The memorandum of agreement, the memorandum of agreement was, I had not read it. I had been informed by our general counsel that it was not a factor in the museum's presentation of its desire to receive an offer. There's the default position. He was overcoached. I once accused a witness in a railroad case of being overcoached. He pulled down his tie. Racehorse always told me the ultimate goal was to get hit in the face by a witness. Pulled off his tie, came across the table, stopped and said, I have not been overcoached, sir, as yet. Question, well, my question to you is, and I took out the sir because I was running out of space. My question to you is, sir, did you conclude the acquisition of Getty intentionally? You wanted to do it. Answer, yes, no question. And you did it knowingly, and knowing of the fact that in existence at the time were the memos of agreement and the press releases. Now he's talking about Pennzoil's rights. Pennzoil had a contract. We did it knowingly and intentionally, knowing that the press release said that they had an agreement in principle subject to a definitive merger agreement. That gets us off down another track, but in New York, once you have all the essential terms agreed on, then you have a good faith obligation to do the tidy up work, the end work. The definitive merger agreement was no more, no less than that. And like my partner Mike Fay and I've agreed, my New York partner, in New York, if you think you have about having a contract, you do. They enforce contracts very rigidly there. Question, do you know, this gets so good. Do you know, sir, of anything that would have prevented the completion of the Getty Oil, Pennzoil agreement if Texaco had not made its offer at that time? Answer, yes, I know of possible things. Question, I'm not looking for possible things, sir. I'm looking for actual knowledge. And the truth is, if Texaco had not stepped in and made its bid at this time, you know of no reason why this merger would not have been completed, do you? Answer, I don't know of any specific reason it might not have been completed, and there's tortious interference. And as one of the jurors who wrote a book, James Shannon wrote a book that I commend to you if you want to get a juror's view, he said by the end of the first hour of McKinley's testimony, he had admitted away his case. Janet and I talked about this at length. I spent day and night reading the transcript. I could hear his voice. Janet too. Janet, and we agreed. It made it harder after he passed away. Joe died full of life. I mean, he had 10 bad days and he was gone. It made it so hard to really give up the ghost. And I can tell you that now that we're through this, it is better. It is easier. Is it for you? I would think. You can hear his voice in all of this.